Good afternoon, ladies and gentlemen. My name is Clara Ho. I'm the Vice Chair of the Board of the Metro Toronto Chinese and Southeast Asian Legal Clinic. It's my pleasure this afternoon to introduce Ms. Carol Goar. Ms. Carol Goar has been a journalist for more than 35 years in Ottawa, Washington, and Toronto. She covered the negotiations and the Marathon Federal-Provincial Conference that led to the Charter of Rights. She followed the struggles of equality-seeking groups for constitutional protection. Since the Charter became law, she has written about the court breakthroughs, the setbacks, the loss of government support for constitutional challenges, and the dawning recognition that legal guarantees aren't enough. Before joining the Toronto Star, she worked as a reporter and writer for several newspapers, a wire service as a news magazine. For 10 years, she served as the Star's national affairs columnist on Parliament Hill. She was also the Star's editorial editor for 5 years. Now she has returned to her first love, writing. She hopes to use her column to illuminate the impact of government policies on people's lives and give a voice to the marginalized and powerless. We would also like to take this opportunity to congratulate Ms. Goar for being the first recipient of the Urban Alliance on Race Relations Ashok Chandwani Media Award. Please join me in welcoming Ms. Carol Goar.
Thank you very much, Clara, for that warm introduction. Is the microphone picking up my voice properly? Can everybody hear? Excellent. All right. I'm a little bit intimidated to be surrounded by lawyers who undoubtedly know more about the Charter of Rights than I ever will, but I've had a little bit of practice asking questions, and that's all I have to do today. The first part of our program, as you've heard, is to set the context and talk about the birth of the Charter with the Honorable Roy McMurtry, who now serves as counsel to the Advocacy Department at Gowlings. But 30 years ago, when the Charter was enacted as part of the Constitution, he was Ontario's Attorney General. That put him at the center of the legal and political action. Can you begin, Mr. McMurtry, by telling us how the Charter came about? There is a widespread perception that you and your provincial colleagues drafted it and decided right up to the end what to leave in and leave out at the many negotiating sessions that led to the final version. Is that in fact?
Well, it didn't quite happen that way. The first Charter of Rights was passed by as you know, Carol, by the Diefenbaker government in 1960. But that was just another act of Parliament, so it had no force and effect, and because any legislation could say, notwithstanding the bill, it was called the Bill of Rights in 1960. Then they had another, and then that continued, but it very rarely was ever applied. And then 1971, they had made another effort to try and this time, to patriate the Constitution with an amending formula and a Charter of Rights. And that almost succeeded, but Premier Bourassa at the last moment withdrew the Quebec support. And then we had the Quebec referendum, as most of us will recall, in the spring of 1980, and during the campaign, Mr. Trudeau promised a renewed constitution, although I'm not sure if he knew exactly what he meant by that. But and I say that he was acting in good faith, and he waged a strong campaign on behalf of Canada. But after the successful federal victory in the Charter of Rights, Jean Chrétien met myself and Bill Davis in Toronto, and then basically that began a long summer of meetings with ministers and a lot of officials both with the federal and provincial governments. But the issue, the politicians, except for two very major issues dealing with the amending formula and the Charter of Rights and the notwithstanding clause, really did not, the political process would make it impossible for us to draft a charter. I mean, if we tried to, it would be like the proverbial group who sat down to draft, to design a horse and ended up with a camel. And actually, the details of the charter had a lot to do with the federal Justice Committee, federal parliamentarians, and there were many dozens, if not hundreds, of Canadians who had appeared before them, and they actually strengthened the Victoria Charter, because in the Victoria Charter, a lot of it was, I'm trying to think of the right word, but for example, it said people would be should not be subjected to, mostly symbolic was what I'm trying, the word I was looking for. Like people should not be exposed or subjected to unreasonable search and seizure, for example. But I'm sorry, in the Victoria Charter, and this is probably getting too complicated, they said unlawful. And basically, it was just symbolic that people had the protection of the law, which they had without. But the Federal Justice Committee changed the rights sections so where a number of them said unlawful search and seizure, unlawful arrest and detention, et cetera, they changed the word unlawful to unreasonable. So that meant a major shift of responsibility to the judges. And so, of course, over the years we've heard a lot about judicial activism and whatnot. But I think it's important to emphasize that the judges did not ask for this authority, but the parliamentarians said, no, it'll be up to the judge to determine in the facts of any one case whether the search or seizure, arrest or detention, and et cetera, was unreasonable. So it's kind of like deciding what is the length of the Lord Chancellor's foot. It gave a great deal of attention to, a great deal of judicial authority. And so Canada really changed from a parliamentary democracy to a constitutional democracy as a result of the entrenchment of the Charter in 1982.